Yes, the reason for contracts being required to be in writing. Before I answer that, let me just say that there are those contracts that are less than 6 months, and they're sort of regarded as oral contracts, and they are allowed under the law. But under normal circumstances, contracts should be in written form. The reason for this is so that things are very clear. Remember, in our previous, we've been talking about employee rights and obligations. It's important to have that on paper so that it creates a sort of relationship between employee and an employer. So the putting it in written form means that you have clearly stipulated the terms of the contract itself. You've also clearly stated the working hours, and you've also stated the terms and the compensation that the employee will be paid. This is one of the main reasons that contracts are preferred to be in writing, so that the terms are in writing. In case of any disputes in the future, you would have the contract as a reference point. In addition to that, it is also important to know what kind of contracts are they under the Employment Act of 2005. This is the main legislation that governs employment matters, as well as the Labor Relations Act. So under the Employment Act, we have three types of contract. The first one is the one I've just mentioned, which is these are contracts for less than 6 months, and which are temporary contracts basically. And then after that, you have fixed contracts. These are those contracts that are for a fixed period of time. This is usually from 1 year to at least 5 years. And then the third type of contract, these are what we call permanent contracts. These are contracts that are more than 5 years, or they are those contracts that end upon the reaching of the retirement age of the employee. So it's important to note these different types of contract as well, because each one of them has different terminal benefits attached to it. Okay, what is the minimum wage in Zanzibar? The first thing we have to understand is that this minimum wage is threefold, as it applies to three different categories of employees. It's not just one figure that applies to everybody. So the minimum wage, or what we called fixed term contracts, is 347,000 shillings. This is the actual standard minimum wage. And then you also have a minimum wage for domestic workers, which is 100,000 if you are providing accommodation for the employee, and it's 120,000 if you are not providing accommodation for the employee. This is for domestic workers. There is also a minimum wage for expatriates, which is starting from $1,000. So if you're going to hire an expatriate, the requirement is that you're going to have to pay them something in excess of $1,000. Another thing that is important to also not forget, I forgot a fourth category. These are those daily paid employees. Those employees, maybe it's a gardener that you only bring in during the seasonal time. They also have their own minimum wage. So you have the minimum wage. We are talking about daily paid employees. So the first one is the skilled daily paid employees. These ones are supposed to get paid 30,000 a day. And then you have the unskilled daily paid employees, and for those the fee is 25,000 kwacha. So just to put that into context again, the minimum wage for standard contracts, which are fixed contracts, is 347,000. For domestic workers is 100,000 to 120,000, and for expatriates is $1,000, and for daily paid employees it's 30,000 for skilled daily paid employees and 25,000 for unskilled daily paid employees. All right, how many hours should employees work under the Zanzibar employment standards? So the normal work week is, we're talking about a 42-hour work week, 6 days a week, 8 hours a day, with 1 hour each day, which is a lunch break. That employees are allowed, and employers are allowed to exceed that limit to a maximum of 45 hours, including Saturdays, which is usually not to work for more than 5 hours. So the standard working week is 42 hours, 8 hours a week, 1 hour lunch break each day, 6 days a week, but it can go up to a maximum of 45. Under what circumstances could employees negotiate this? These are what you call those collective negotiated agreements, be it under a trade union. It is also important to know that for the time that the employee works outside of those working hours, now we're talking about overtime, the employee is entitled to compensation for that overtime. The rate is usually double the hourly rate of their normal working days. So it's important to know this, and it's important to make sure that employees are being compensated for overtime accordingly. So in summary, a normal working week is 42 hours, 8 hours a day, 1 hour lunch break each day, 6 hours a week, right? This is that amount could exceed to about 45 to 48 hours a week, but this is in the event that it has been bargained by the employees collectively. Another thing that employers must know is that the employees are entitled to compensation for overtime. This is the hours that they work beyond the required time. And the rate of calculation for this compensation is double the normal hourly rate of the normal course of employment. I hope that clarifies that. Okay, so this is a disciplinary issue. What should be the course of action in the event that you have reason to believe that your employee is doing some fishy business? So the first thing that you must do is to notify the employee of that particular offense, right? So this is done through what we call a show cause letter. So in this show cause letter, you explain what the offense is, and normally at the back of the Employment Act, you have a list of offenses that have been categorized as employment offenses, and each of those offenses has been given an appropriate punishment, different forms of punishment. So if you believe that your employee has committed one of those offenses, you write to them a show cause letter informing them of that allegation, and then you also give them 3 days within which they must explain themselves. This is done in order to comply with the rules of natural justice, where everybody has the right to be heard. So that's step number 1, where you notify the employee through a show cause letter. Step number 2 is the response. So the response here will happen in 2 ways. Either you will receive a satisfactory response and you keep the employee, or you will receive an unsatisfactory response and you might need to take action based on that, or in some cases the employee might not respond or appear to the disciplinary hearing. So it is now at that point where you can now take action. For instance, that if the employee's explanation to the allegation is not satisfactory, then you can take the appropriate action, be it a verbal warning, a written warning, or a final written warning, depending on the offense itself. So in the case of stealing, That's different because stealing is as a criminal offense. So normally in the case of stealing, you are required to suspend the employee on half pay pending inquiry. This could be an internal inquiry, or you might have reported the matter to police. But you can only take that action of suspension on half pay after they have responded to the show cause letter. And in the event that you have found the employee to be criminally liable, then you may terminate or dismiss them. But in the event that you have found out that the employee is actually not guilty, then you will have to reinstate them and repay them for those payments that were deducted, the half payments that were deducted during the inquiry or during the criminal investigation. So normally there's also a question that arises here. So for instance, that action has been taken and you're the employee. Normally I always happen to end up representing more or less employers in this case. But let's say you're an employee, this action has been taken, the right procedures have been taken, the disciplinary hearing has been taken, and you are basically aggrieved by the decision of your employer. What other legal remedies are available to you? This is where now we have the dispute handling unit. So the dispute handling unit was established under the rules of Zanzibar. Through the dispute handling unit, we have different stages where employee and employer disputes are managed. So the first stage would be mediation, where the two parties go voluntarily to a mediation session to try and resolve the matter out of the court. And if that fails, the next stage is arbitration, which is legally binding. And then an arbitrator is appointed by the unit. And then should that fail, you may bring the matter to the High Court under the Industrial Court. So these are the legal platforms that are available for legal remedies for both employees and employers. That's worth noting as well. Assuming that there is some disagreements between the employer and the employees, and that you have followed those steps that I've just mentioned on taking disciplinary action, and now you are about to terminate that employee. So this is what we're talking about. So the most important thing that you need to understand is that you can only terminate an employee based on grounds to do with their conduct at the workplace or their performance at work. These are the main issues. Or termination where the contract itself has reached its period, or mutual termination. But in this case, we are talking about termination based on conduct and performance of the employee. The last procedure that you will need to do is the notice itself. Now that you have decided to terminate the employee, you have confirmed the procedure, you have confirmed that it is related with their performance and their conduct, and now you want to give out the termination notice. So the termination notice will be affected by the type of contract that employee is under. So if it's an employee that is under a temporary contract, then the notice will be 2 weeks. If it's an employee that is under a fixed term contract, then the notice of termination will be 1 month. If it's a notice of termination for an employee who is under a permanent contract, then you will have to give them a notice of 3 months or payment in lieu of that notice. Hope that provides some clarity. I know that this is a very delicate topic, and I know that a lot of people have a lot of questions on this matter. So if I've missed anything, please, you're always welcome to visit us at our offices, and I'm also happy to welcome any investors that would like to come and have a chat with us about these things and see where we can go from there. It's always good to share the challenges and the ideas, and we brainstorm together. Anyway, that's it from us for this week. I hope you have a lovely week ahead. Thank you for supporting us, and see you again next time.